First tonight, the legal battle over the new Naira policy continues. Kaduna, Kogi and Zamfara states have initiated contempt proceedings against Attorney General Abubakar Malami and CBN Governor Godwin Emefiele over their failure to comply with a Supreme Court order.
Well, the three state governments had initially filed a suit against the federal government and the CBN on February 3rd over the Naira redesign policy. In the new documents filed before the Supreme Court, the three states cautioned Malami and Emefiele about the consequences of their continued failure to comply with the court's order, suspending the ban on the old 200, 500 and 1,000 Naira notes. The forms are now part of the applications awaiting the Supreme Court's consideration as proceedings resume tomorrow. Meanwhile, the CBN has insisted that only old 200 Naira notes have been reissued as directed by President Muhammadu Buhari. Well, in a statement, the CBN dismissed some media reports that the president approved the reissuance and release of the old 500 and 1,000 Naira notes as legal tender in the country. It describes the reports as fake news and pledges to work with security agencies to unravel the perpetrators of such reports.
All right, analyst and lawyer Frank Tietie joins us now to make
sense of
the whole issue. For the average Nigerian, perhaps let's see how we can start breaking it down. Now, this is straight to the Supreme Court. This is quite different from what we've seen before. And many had interpreted that the Supreme Court can only be between state and states, and but this is bringing some individuals into perspective. Makes sense. How is it that the CBN governor and Malami are now in this?
We're dealing with issues of contempt here, that is disregarding the orders of the court. It's a very serious offense in our constitution and in our legal system in general. There is a mandate on the government to ensure that court orders are enforced at all times. And every court in Nigeria, from the highest court to the lowest court, has a responsibility under the provisions of the Sheriff and Civil Process Act to enforce court orders and to ensure that courts, the inherent powers of courts, are actually respected. So the interesting dimension that this is having is that you do not necessarily have to approach the Supreme Court to enforce any form of violation or disrespect for a court order. You could actually have approached any of the courts, particularly the High Court, to show that such and such a person can prove the facts and all that, and then initiate contempt proceedings against the party. It's interesting that the Attorney General is actually a party in the case before the Supreme Court, but not the Central Bank Governor.
Exactly.
However,
not the Central Bank Governor.
However,
go ahead.
The Central Bank Governor, in the eyes of the law, is a servant of the federal government. And if you look at the totality of the order of the Supreme Court, is to the federal government through the Central Bank of Nigeria or any of the servants of the federal government, including commercial banks, because they are regulated by federal law and not state law. So it's quite an interesting conundrum.
It is a very, very interesting conundrum. And I'm wondering, the Supreme Court really has been silent on the issue of whether there's been a contempt or not. Who exactly, at this point, should determine? Because it looks like the state governments are taking it upon themselves to say, look, there's been a contempt of the interim injunction of the Supreme Court.
That's how it should be. Okay. The Supreme Court doesn't really bother about whether or not its orders are obeyed. If you check its history, it's silent on it. The Supreme Court, at the level of dispensing justice, it's a most superior court, it's a parent court. It's concerned more about its constitutional responsibility under Section 6. If you recall, the Supreme Court has given several judgments asking many politicians, whether in the House of Assembly or House of Representatives or Senate, that have been sacked to return whatever salaries that have been paid to them. The Supreme Court doesn't bother to know whether any of those persons affected have actually complied with those judgments. Now, but those persons who are interested, who are affected by the judgment, must be the ones who take steps to ensure that those aspects of the judgment are enforced, and so there's a procedure for that. So that's why there's a particular law separate from other laws. It's called the Sheriff and Civil Process Act, and there are rules of procedure, the judgment enforcement rules, to which step-by-step procedures to be followed by the sheriff of the court, by the judgment creditor, that is the person who benefits, and how the judgment debtor should be treated. In most cases, and ultimately, the judgment debtor is usually committed to prison, if in a manner that.
So in this case, where you have the three governors now, talking about the, implications of failure on the part of the CBN, of course represented by Emefiele, and Malami, failure to comply with the Central Supreme Court.
It's not automatic. It's going to be a very tough job for any lawyer and any party to prove. First, you have to file, say, Form 48 to prove to the court that, there are separate other provisions on the Supreme Court Act and the Supreme Court rules anyway. But you have to, if you're going strictly in terms of contempt outside the face of the court, you have to convince the court that there is a semblance of disregard for its orders. The court has to agree with you. So you wonder whether the Supreme Court will want to come down to deal with, to invoke its original jurisdiction in a criminal matter, because what we don't often appreciate is that contempt proceedings are criminal proceedings, because they are proceedings which end up in, putting someone on trial and then ultimately sending the person to prison if convicted by the court. So the Supreme Court will unlikely do that.
Apologies. Let me jump in here, specifically talking about prison. In this case, the chief law officer is the man representing the president, who has immunity. So, and we're not trying to jump the gun, but in cases like this, when you have someone who doesn't have immunity and you found wanting, what then happens?
We've seen several cases like that. I recall Obayo when Attorney General of Edo State, who was actually sent to prison by a judge of the Federal High Court. The judge mobilized 200 policemen awaiting him. When he came, he said, you were running foul of the rules of this court, you disobeyed the order of this court, and without further adumbration, put him on trial, found him wanting, and sent him to prison. It was an embarrassment. And in this case,
so there are presidents.
Of course, there are presidents. And the courts in Nigeria can be very powerful, and especially with the cooperation of the police. So is the National Assembly if it decides to use its powers. Now, sometimes when you can't go after the master, you go after the servant. In this case, the Attorney General is going to be used as a scapegoat, because the actual person who is in disobedience of the Supreme Court directive order is the president. And the Attorney General exists today because the president appointed him. The loyalties of the Attorney General is supposed to be to the Federation, because the Attorney General of the Federation is supposed to, but the Attorney General can exculpate himself, because immediately after the ruling was given, the Attorney General gave a public declaration that he was going to comply. But he could only comply to the extent of his ability. The Attorney General doesn't control the issuance of notes and the distribution of cash across Nigeria. So what is he expected to do? To now fight the CBN governor, to now take policemen to compel the CBN governor to start distributing cash? That is unlikely.
Frank, quite an interesting case here. Now, the president's immunity will lapse by May 29th.
Right.
Before midnight. So if anyone is still hard on by what has transpired, can a citizen then bring the case before the president? In that case, then former president.
Who no longer has
the
immunity.
Scapegoat is usually the Attorney General. And I'll give you an example of Andoka. As Attorney General to Musa Yar'Adua, Mario Yar'Adua as president. When he left government, I remember that cases were filed against him in court, and there was the disciplinary measures were taken against him, and part of which was that he was disobedient to court orders and that he was making reckless statements. They were quite serious. All court orders were insecure to the extent that they were barring him from taking up future public positions, and there is a body, a very, very serious body in the legal profession known as the Legal Practitioners Privileges Committee, that confers, sanship, or what we call the privilege of becoming a senior advocate of Nigeria. That same body is able to strip any of its appointed senior advocate rank, and I have seen even this president as Attorney General has been brought before that legal practitioners privileges committee before for certain things that he's done, for asking that he be punished. And so there's the fall guy here always for all presidents, whether it was President Goodluck Jonathan or God bless his soul, former President Musa Yar'Adua, I mean Omar Yar'Adua. It is the Attorney General that is the scapegoat.
Okay, so
on him.
We're likely to get the same scenario play out. That's what you're saying. Frank Tietie, Arise News analyst, thank you very much for joining us on Newsnight.